morning, or is it good day to everyone? It's Titi Tobani. Kindly please, first thing first, as you know, subscribe, like, comment, give us super thanks and thumbs up. This is a special podcast, and I like people to subscribe and join the podcast, join the channel, in order to receive special content in the form of vlog. I would like us to deal with the issue of high treason and espionage. Maybe some of you have already seen on the social media and also on the media streaming the issues of political parties. Some of politicians making certain remarks, others going to the extreme of going to other countries. And I'd like us to look at the definition of high treason. And some of these politicians and political parties might be charged under the offense of high treason. And in order for you to learn more and get more with regard to these offenses of high treason and espionage, kindly please join the channel. It might just cost you less than 20 Rand per month, but it's for the benefit of everyone. Kindly join. Then such analysis of high treason and espionage will be done on the vlog. So, secondly, I would like to deal with the case of Falcon Evans case. It deals with the issue of interdicts. Someone asked me that question on the previous occasions, but because of time constraints, I could not respond. The case deals mostly with applications, proceedings, where decision may be made without oral evidence being heard. In this regard, also see White Man Trading S JW Construction versus Head 4 Pty Ltd and another, in brackets 2008 volume 3 SA 371. Then we are moving to the issue of section 317 and section 217. I would like people not to confuse these two sections in terms of the Criminal Procedure Act. Section 317, section 317 deals with suspected irregularities during the proceedings. Irregularities during the proceedings meaning that whereby one of the litigants, either the defense or the state, alleges that there might be irregularities, then a special entry may be made. A special entry may be made by the Honorable Court in that regard. In terms of section 217, section 217, I think up to so far, everyone must be knowing that it deals with confessions. It deals with confessions of an accused person. And everything must be done in terms of the law and within the framework of the law and the Constitution when someone intends to make confession. In the matter of M. Sibia and 4 others with regard to the killing of Senzo Maiwa, with due respect, I intend to differ with the Honorable Court in this regard. When a suspect is being questioned by an arresting officer, a lead investigator, or any police officer for that matter, and during that conversation or during that questioning, it is found that the suspect intends to make a confession, then arrangements are being made to appear before a magistrate to take down such confession. A magistrate who is taking down that statement knows very well that is taking down a confession. So it cannot be that it is the only honorable court in Kasu which will determine whether it's a confession or not. The honorable court duty, it has to determine whether the confession was done within the framework of the law and no rights were violated. By the time when those confessions or statement is taken, the magistrate was aware that he's taking a confession because it is evidence before the court that Ms. Colonger was phoned by one presiding officer in a particular court to say, may you kindly come and assist us, someone wants to make a confession. And such arrangements were made. Ab initio, when such confessions were taken down, the presiding officer didn't rope, meaning was not wearing her gown as the magistrate. In essence, that was unofficial. And someone can argue that such confession, it is inadmissible. The magistrate introduced herself to the suspect and informed the suspect that she doesn't know anything about what she is about to say, or in order for her to write it down, and the suspect has the right not to say anything, and the suspect has the right to inform the magistrate that he was coerced in making such statements. Therefore, it can be that the Honorable Court is correct to state that the witness, Colonger, did not know by that time that she was taking a confession. And with due respect, the matter of Malin, the Malin case, is bad in law. It's very bad in law, and it was decided by a single presiding officer. Members of the public must note that the purpose of case law and precedents is to convince the present matters, and they compare with what transpired in the previous case. It doesn't mean that the Honorable Court is bound by the decision of that previous case. Its only purpose is being persuasive. Being persuasive is not a must that a present court in Kasu must be bound by the decision of the previous ruling in another court. It is the same court in this matter of the murder of Senzo Meiwa that said in passing and made a comment that in a particular case, who was the presiding officer? And the presiding officer's name was mentioned, and then the Honorable Court said, no, it was only one, anyway, it was only one presiding officer. So it must be noted that when you compare a present case and a previous case, similarities must be drawn between the two cases. You don't just compare with regard to the ruling or the comments of the Honorable Court. For example, in the matter of R versus Hepworth, that matter was dealing with a murder incident. Now, in Kasu, in MCB and 4 others, we are also dealing with a murder case. And it is very important to note that a presiding officer cannot just keep quiet and be a referee without participating and asking clarity seeking questions. It is very important that the presiding officer must ask clarity seeking questions and must assist the other side when is off the line. The most important principle in that matter is justice must not only be seen to be done, but justice must be done. Justice must be done and must also be seen to be done. It's very important for us to understand that justice must not only to be done, but it must be seen to be done. Justice must not only be done, but it must also seem to be done. It means a lot of things. It really means a lot of things. For example, a presiding officer must ask clarity seeking questions, but must not take sides. Must assist where the other party is off the line. The presiding officer must not seem to be leaning towards the other side in the proceedings. Because this matter is of a public concern. And it has drawn public interest. It is this matter, or it is this kind of one of the matters that will teach the public how legal proceedings or jurisprudence in South Africa operate. I would like to go back to the issue of high treason and espionage. You must remember these are 2 common law crimes, and espionage, it deals with regard to intelligence and counterintelligence. It deals with the spies, so-called secret spies. If a particular agent can take information with regard to another country, whereas is employed by that country, and take that information to another country, illegally so, such agent can be charged with espionage. It is very important for us as South Africans to guard against the crime of high treason as well, especially when elections are coming. On the 29th of May 2024, we are going to elections. It is very important to be careful and cautious on what we are doing and on what we are saying, including on what we are posting in the social media. We need to be careful with regard to that. We need to avoid posting false information. It is very important because I've noticed a trend in the past 2 weeks that some people want to plunge our country in a civil war because of their utterances and also regard what they post on social media. We need to protect our country. We need to assist our law agencies. We need to assist our law and order agencies to protect us as a country. To avoid bloodshed. These things, they go hand in hand. As I said before, law and politics, they go hand in hand. As you have seen the matter between MKP and ANC in courts. We cannot run away from the fact that law, religion, and politics, they go hand in hand, but we must be able to draw the line between the three. There is a Rubicon that must be drawn. Let's say, for instance, as it stands now in MKP and ANC matters. As it stands now is 1-0 in favor of MKP. Then we are waiting for another judgment. We don't have to anticipate the outcome, but we need to put law, logic, and sense in the expected outcome. In terms of the Constitution, everyone has the right to organize themselves, the right to belong to an association, the right to stand for office, the right to be elected, and to vote. So there's no court on the land that can deny anyone that right, which is there in the Constitution. As we all know that the Constitution is the supreme law of our country. However, we must remember Section 35, limitation clause. For example, Mr. J.G. Zuma cannot stand for office. In fact, let me put it this way, he cannot stand to be elected as the Member of Parliament for MKP, if not the President of the country. I stand to be corrected whether he is a Member of the Parliament or the President because of the previous convictions he has. It is very important to note that This is not a political debate. It's a legal debate. If you can hear me, I'm talking about previous convictions. And I'm also talking about limitation clause in the Constitution. However, I do note that it's linked to politics. But now here we're dealing with law. As I'm saying, it's very important for us to be able to draw the line. During the publication of the candidates list and the period of objections was opened, objections were raised. Some of the objections were dismissed by the IEC, and objections against J.G. Zuma were upheld by the IEC based on the fact that J.G. Zuma has a previous conviction, so he cannot stand for office in the parliament. He cannot stand to be in the parliament because he has previous conviction of more than 12 months. Another issue here is that J.G. Zuma had already ran 2 terms as the President of the Republic of South Africa. Now, in terms of the law, this can create another problem. You must listen very carefully. I'm not talking politics. In terms of the law, this can create another problem in that MKP want to use his face to converse for votes during campaigns, and Mr. J.G. Zuma to be the face of MKP on the ballot paper. This is law, ladies and gentlemen. This is law. It's not politics. It's very important you must understand that. Someone can raise an issue that it can be that someone who's being barred as well, not allowed to go to parliament, to be used as the face of MKP to garner votes that can take them to parliament. Just think about that scenario. Legally, it can be found wanting. What is very concerning on my side, again, is a leader of DA who went to countries overseas to ask them to assist in any other way with regard to the elections in South Africa, approaching another government. If someone can look at the definition of the crime of high treason, in terms of the South African law. The moves of such political party leader can be found wanting. I leave it to you, ladies and gentlemen, and apply your minds on that. Go and look for the definition of high treason in terms of South African law, espionage in terms of South African law, or just the definition of espionage. And most importantly, as when it comes to the upcoming South African elections. You know what happened of late in the International Court of Justice, where the South African government took Israel to the court. And furthermore, the allegations of threats made by the Minister of International and Cooperative Affairs, Honorable Pandor, and of late, the utterances of the IDF, Israel Defense Force, when it said it might extend its attacks or war to other countries, even if it is afar. From Israel. And furthermore, it's not a secret, doesn't need a rocket scientist, that most of well-advanced countries in the world, they have their spies or intelligence agencies or agents all over the world in other countries, spying in other countries as well. It is very important that our South African authorities be on high alert. Members of the public be on high alert in order to protect our sovereignty and our country. Our sovereignty is very important, just like it is to other countries. In Africa, many people, they thrive, they loot during wars. Where there is a war, some people is an opportunity for them. Where there is a war, it is an opportunity to other people. People loot and steal and further commit economic crimes during war times, which takes us back to the issue of espionage. We have the so-called economic espionage. As we have seen with regard to Juste and Vice, whereby Steinhoff resources were looted. It is a criminal offense when someone engaged on inside trading. It is an economic espionage. It is very important to everyone to note that we must not be allowed to be used by other people to plunge our country into a mayhem and catastrophe. We must not be allowed to be used by other people for their own greedy needs during the war. Everyone can note that during apartheid, during the struggle against apartheid, some people were thriving, looting and stealing, empowering themselves, making a lot of money to such an extent that some of them would even go and meet the Oppenheimers. It was during the struggle. In that regard, I'll pause on the issue of high treason and espionage. If you want to know more and get more material, kindly join the platform. Kindly join here. It can only cost you maybe less than 20 Rand a month. Subscribe. Hit the notification buttons. Like. Give us thumbs up. And comment. Talking about comments, I would like to go for now and peruse comments and respond where I can. Remember, this platform, we are here to assist each other, learn from each other, and we do not take sides. We are apolitical. Let me kindly go to the comments, if you may allow me. Alu, Mr. TT, the day you left the censor case, you said the accused did not know each other. Why did you lie? Alu, that was not the day I left the case. And that's indigenous on your part. It is indigenous because I never lied. As attorneys and legal practitioners, we work on mandate. Hence, I say to you, what you said is indigenous. We legal practitioners, we work on mandate. You are disingenuous because an attorney cannot come up with a statement without receiving instructions. You are disingenuous because the attorney cannot thumbsuck a fact. You are indigenous because I only mentioned that in court. You are disingenuous because the new practitioner who came through back doors mentioned something else from someone who's not the accused. According to him, he was allegedly told by someone who is not the accused. I don't take something from someone who has not instructed me. I only work or submit to a honorable court based on instructions. If you have noticed, when I was appearing, whenever the state witness had already testified under examination in chief, before I could even proceed to cross-examination, I will firstly approach the client to take instructions or to confirm if the accused still stands with the previous instructions he gave me based on the testimony rendered by a state witness. It is very important for the members of the public to know that this channel is not only about the Senzo Meyiwa murder trial. As you have noticed today, I started on another note. There are other matters which are before the courts. There are other issues that affect the entire society. Whether being bad things or good things. On the issue of good things, I'd like to congratulate Taylor from Edenvale, who won the Emmy, and she just came back to the country to celebrate Easter. And I'm very happy for her. I mean, who can imagine someone from your hood in Edenvale can reach such a milestone? So we can do it. If you believe, you can do it. And I would like to say to people who made a meal out of nothing when Taylor held her Emmy after the minister has touched it. You don't know what happened. We're not there. We only saw that from a distance. Some of us were at the airport, but we could not hear their conversation. Maybe the minister said, "Can I just touch it?" And Taylor had to raise it up. And she could not raise it up on the face of the minister. That's why she had to raise it up on the right side, up her shoulder. Anyway, it is her award. It is her Emmy award, and he's got the right to protect it. Thank you, Musa Banda. You're welcome. Alu, I think I've answered you as well. Hence, I was saying it's very important to note that our country needs us. Our country needs us to protect it against those people who want to destroy it. Therefore, it is very important for us to also have responsibility on what we do, post, or say. Remember, we are all living in the constitutional democracy. Everyone has rights. Rights of each and every person against each other, and the rights of persons against organizations. Besides all those rights, we also have duties. Each and every right, Alu, goes with duty. Duty is responsibility. When exercising your right, you have the duty to make sure that you don't violate other people's rights. For example, why this person of a particular party who went to an overseas government could not go to an organization there in overseas, in that country. There are so many organizations, non-governmental organizations. There is United Nations, there is AU, there is EU. Most importantly, even in that country, this person went. There are a lot of them, the NGOs. Who can monitor and become observers in the elections. It is uncalled for such person to go to a particular government. And I won't be shocked if someone can open a case against that political leader. There is one organization, and I'm going to mention it by the name. I'm going to mention it by its name. This organization it has been there for a long period of time. And I appreciate their presence and their assistance. I just pray God that they don't get influenced by a particular government where this organization comes from. USA Aid, USAID. Everyone must be or might be aware of such organization. It is very helpful, and I've seen it around after the date of elections was announced. It happens that I see cars, motor vehicles branded in that name. Note that it is the same organization which was there during apartheid, during our struggles against apartheid. Such organization has been there, helping where it can. Hence, I'm raising the point that I pray that it doesn't get influenced somehow by government of that particular country. On that note, I would like us to go to the issue of the national speaker versus the NPA. In terms of the Constitution, no one is above the law. Hence, I'm saying, even on that issue of high treason, someone can open a case against the leader of that political party. And no one can tell the NPA when they can charge them or when they cannot charge them. The NPA is said to monitor litis. The NPA can decide whether a certain person must be arrested or not arrested. The NPA can decide on whether the matter before it must be placed on the roll or not placed on the roll. When the police officers, the Hawks, makes their own investigations, after they've concluded or completed making investigations, then they hand over the docket to the NPA to make a decision. Based on the facts before them, the NPA will decide whether they prosecute or they do not prosecute. There are 2 points I want to raise here. When the NPA decide not to prosecute, doesn't mean it is the end of the case, but the NPA basically means, and it is saying to the police, go back and investigate this point and this point and this point. Then you come back to me. Then after the police have done so, the police will approach the NPA again to make a decision on that docket. In the event that the NPA make a decision for a particular person to be subpoenaed and appear before a court, such subpoena or summons will be issued, requesting such a person to appear before a court. Such decision is made based on different facts: the seriousness of the offense, whether such particular person is a flight risk, whether there is the likelihood that if such person is subpoenaed to appear or given summons to appear in court, will evade justice, whether the likelihood, the chances of extraditing that person to come and face trial, and if the NPA is of the view that there's no need to issue a warrant of arrest, but that person be subpoenaed, so be it. The NPA will issue such document. However, in the event that the NPA is of the view that the bail must be set for a particular person, when such person makes first appearance in court, the NPA will submit that they request to the Honorable Court to set a bail to the accused. Then that will be done. It will create constitutional crisis, or it will create a mess in the whole country, whereby everyone can tell the NPA, when can you prosecute me, or when can you bring me to court? However, when the NPA exercising its rights, it has the duty to respect the rights of the citizens. Hence, the NPA is obliged to make a reasonable decision. Let's go to the event whereby a matter is nolle prosequi. Normally, when they say the matter is nolle prosequi, it means that the NPA made the decision that there is no case for that accused person to answer. The prospects of success on that case are very low. Then the NPA will issue a nolle prosequi certificate. Then that will be the end of the case. They will not take it further. It will be the close of the matter. Then a private person can come and say, can you please issue me with that nolle prosequi certificate because I want to go for private prosecution, which is allowed on the condition that such private person pays a deposit before they can proceed with private prosecution. In the matter of docket 375, in the senso major matter trial, that is the bone of contention which started between the time the matter was appearing before Honorable Judge Maumela, wherein me and Tifo were appearing. We pleaded to the NPA to either prosecute those people in the house under docket 375, those alleged witnesses, and others, in this case, under docket 375. Then the NPA refused to prosecute. They never noted the matter. They refused to prosecute on the basis that they are waiting for the outcome of the docket 636 before Honorable Judge Maumela and now Honorable Judge Mkwahle, for the Honorable Court to make a credibility finding in order for the NPA to decide whether to prosecute those people who were in the house under docket 375. It must be noted that not under docket 636. However, we insisted that the NPA must decide. If they don't prosecute, then they must issue a nolle prosequi certificate, of which the NPA did not issue. Hence, that docket 375 is still stuck. Besides names mentioned, besides names of a particular person mentioned in this 636 before Honorable Court Mkwahle by state witnesses through their evidence, testimony, or affidavits read into the record, the NPA is not taking any action with regard to that mentioned name, because the NPA is Dominitis litis. It is their right. However, when exercising their right, the NPA must not abuse or trample on the rights of others. The NPA has the duty not to trample on the rights of others if there is a prima facie case against a particular person. A decision must be made on whether they prosecute or they nolle prosecute the case. In this regard, you remember the matter of DA versus JG Zuma and the NPA, whereby an application was made by the DA to the court to compel the second respondent, the NPA, to charge the first respondent, JG Zuma. The reason why JG Zuma was cited because he had interest in the matter. However, what is important is this was the matter between the DA and the NPA. the DA argued that there is a prima facie case for J.G. Zuma to answer. And the court ordered that on face value, the NPA must charge J.G. Zuma and change their decision not to prosecute him. That was a bad in law and watershed ruling in our jurisprudence with regard to the separation of powers. In that, the court interfered with the duties of the other institution, the NPA, by ordering the NPA to charge J.J. Zuma. People argue that it violated the principle of separation of powers. In so doing, someone can say the court might have already decided the direction in which this matter will take. But note here, it is the legislators who made a big and huge mistake. If you can notice that both the judiciary and the NPA, they are under one section. They are under Chapter 8 institutions. So I would like to leave that one to you to digest it and establish if is there any separation or any interference with the separation of powers rule. I'll give more info on my vlog, which will only be sent to people who joined this channel, to those people who subscribe to this channel and joined it. I'll be sending vlogs on my channel. It is very important to note that even the speaker, when she asked for copies of the docket, the names of the witnesses and the evidence that the NPA has against her, it is unknown and unheard of, because the matter is not yet before the court, and the NPA has not yet informed the court whether it has completed its investigations. Even the court which this matter is now before it cannot have sight of the docket, cannot have sight of the names of witnesses, evidence that can be used against the speaker, because the matter is not yet at trial. Hence, I'm saying, and I did say it before, whoever gave access to the docket to a particular person who belongs to a one forum in the matter of Senzo Mewa murder trial, before such information can be given to the defense or the Honorable Court, and before that matter can be set down for trial, has committed an offense. Such person and this person from that forum committed offense. And someone can open a case against them in that regard. More will also come on the flock to those people who subscribe and join the channel. It can only cost approximately less than 20 Rand per month in South African money. Before we wrap up, let me try and go through your questions. I can see Cynthia Malope. Afternoon, advocate. Hi, Cynthia. I'm not advocate, I'm attorney. Thank you. You say, I'm not sure if you have addressed this one, but I'm interested to know if it's true that Judge Maumela appointed himself in the Senzo Mewa case. How possible is this statement? Unfortunately, it's a good question, but you're asking it to the wrong person. However, I'll take what the Honorable Judge President said, and as the officer of the court cannot mislead anyone, even if in public he cannot. My understanding is that Honorable Judge Momela was meant to deal with pre-trial issues on the matter. And once the matter was ready for trial, he was supposed to have allocated it to a particular judge or take the matter back to the Honorable Deputy Judge President and the Honorable Judge President, who were going to decide to whom this matter must be allocated to. But now, with due respect to the Honorable Judge President, they cannot put the blame squarely on Honorable Judge Momela, because if they are the supervisors, they should have supervised that, oversee that Honorable Judge Momela doesn't proceed with trial. So basically it means they also slept on their duty and they allowed this one to slide and go south. Top G, advocate, sorry, I'm not advocate, I'm an attorney. Tell me about planning and environmental law, please. Mary, thanks. Your question is very broad. I mean, you're talking about planning and environmental law. Kindly be specific, because we have town plannings, we have all kinds of environmental law issues. Kindly, please be specific. I'm supposed to have finished up at 10 minutes ago, and after this podcast has been posted, you are allowed to post those questions and clarify them, and I'll come back to you and respond. Derek S.A. Mazibuko, according to the law, is it possible, Judge Arthur, to convict the accused with all the contradictions that we have heard so far in the Senzo Mewa case? Mazibuko, my answer is, when a honorable court makes a ruling, looks at all facts placed before it. In some instances, a honorable court may overlook or sidestep other issues which might have a particular influence on the outcome of a matter. And parties to the matter who feel that they are not happy with the ruling of the Honorable Court can refer the Honorable Court to those facts which the Honorable Court sidestepped or overlooked. Hence, in our jurisprudence, we have application for reviews, applications for appeal, we have notice to appeal, petition, rescission, and variation. And also not forgetting application for a presiding officer to be recused on a matter. Yeah, thank you, ladies and gentlemen. If there is any other points you want to raise, I'll check them on the uploaded podcast. Have a nice one. Good afternoon. And have a good Easter Sunday. Thank you.